For the record, this continuation, State of Tennessee versus Billy Turner. Ms. Turner is present. All trial parties are present. We're still scanning people to get them to the courtroom. And for the record, before we took the break, I'd make copies of the charge for the lawyers. For Mr. Turner, and also some of the media outlets asked whether or not they can get a copy of the charge, and made a copy of the charge with media also, since it is a public record and would aid them also. Have both sides had a chance to look at the charge? Any additional concerns, objections, or recommendations?
Nothing from the stage, Judge.
No, yeah.
Need to put this on the record also, so it would not be any sort of an ex parte communication. But Mr. Perry, Mr. Thomas, the last witness that you called, Miss. Yes, sir. Thank you. I actually ran into her this morning as I was coming into the courtroom, to the building rather. Miss Jennifer Bogan, and she was standing outside of the elevator, passed by, and didn't know who she was. And just the way I was raised, looked at her and said good morning, and she said good morning, and realized a few minutes ago that's the same person that you used to put on the witness stand. So that's the extent of the conversation. She said good morning to her, and she spoke back and said good morning, and I walked past her and got on the elevator. So I just want to put that on the record. I did tell her good morning this morning. I had no idea that she was going to be here as a witness.
Yes, sir. Thank you.
Yes, sir. Are both sides ready to proceed?
Yes, sir.
And again, based on the communication from the jury, what I'm going to do is read this jury charge. We'll read it in its entirety. Normally we read the first 24, 26 pages, but I will read it, the entire jury charge, so that we'll not have to read into the charge on Monday morning, and we will recite this jury. And we'll start with jury arguments at 10 o'clock on Monday. Again, I have to qualify the March term Shelby County Grand Jury for the next 2 months, and that will be at 9 o'clock, and we'll start jury arguments promptly at 10. Deputy Smith, you can bring in the jury, please, sir.
Yes, sir.
Yes, sir. Thank you, ladies and gentlemen. Everyone can be seated. Deputy Smith, pass this to the jury for me, please, sir. 7 and 7. Thank you. Ladies and gentlemen, the evidence in this case has been completed, and these are your final jury instructions. Again, you have your own copy. I'm sorry, it's not a copy. You have your own jury instructions. Don't copy those originals. They're identical to the jury instruction that would be in the court's jacket. They're all signed in blue ink. You can write, highlight, underline anything on those instructions that you want to. And again, I wish I could just tell you to read this for yourselves. When you get back to the jury room, we are required to put this law in writing for you. And it's interesting because when I first started practicing law in Tennessee in Shelby County, we did not used to give jury written instructions. In fact, judges didn't even put them in writing, they just read to them. So we changed the law to make sure that it is in fact written. And I give you a copy of the instructions, so if you have a question about the law, once 12 of y'all start deliberating, you can look at your own personal document rather than have to share one document amongst 12 people. You are free, feel free to read along with the court, but you're not required to read this. This is State of Tennessee versus Billy Turner, indictment number 1705881 in the criminal court for Shelby County Division 7, and these are your final jury instructions. Members of the jury, the evidence in this case has been completed. It is my duty to instruct you on the rules of law that you must follow and apply and decide in this case. The law applicable to this case is stated in these instructions. It is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each instruction in light of and in harmony with all the others. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law under the direction of the court. You must apply the law to the facts and decide in this case. You should consider all of the evidence in the light of your personal observations and experiences in life. Count 1 of the indictment charges the defendant with the offense of first-degree murder. The offense necessarily includes the lesser offenses of second-degree murder, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, and criminally negligent homicide. Count 2 of the indictment charges the defendant with the offense of conspiracy to commit first-degree murder. The offense necessarily includes the lesser offense of facilitation of conspiracy to commit first-degree murder. Count 3 of the indictment charges the defendant with the offense of criminal attempt first-degree murder. The offense necessarily includes the lesser offenses of facilitation of criminal attempt first-degree murder, criminal attempt second-degree murder, facilitation of criminal attempt second-degree murder, criminal attempt voluntary manslaughter, facilitation of criminal attempt voluntary manslaughter. Although there are 2 persons named in this indictment, you are to determine the guilt or innocence of only Billy Turner at this time. You are not called upon to return a verdict as to the guilt or innocence of any other person or persons. You must determine whether or not the evidence in this case convinces you beyond a reasonable doubt of the guilt of this defendant without regard to any belief you may have about the guilt or innocence of any other person or persons. There are 3 counts in this indictment. You ought to treat them as separate and distinct cases at all times. The defendant pleads not guilty to every offense charged and included in this indictment. The indictment in this case is a formal written accusation charging the defendant with a crime. It is not evidence against the defendant and does not create any inference of guilt. The law makes it the duty of the court to give in charge to the jury all the law relative to the case on trial. The duty of the jury is to consider carefully all the evidence delivered to you in the trial and, under the law given you by the court, to render your verdict with absolute impartiality. The jurors are the sole judges of the facts and of the law as it applies to the facts in the case. In reaching your verdict, you are to consider the law in connection with the facts. The court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. You shall not have any sympathy or prejudice for or against the defendant, or for or against the state of Tennessee, or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think truth and justice dictate. You may consider every fact and circumstance in the case in arriving at your verdict. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with those rulings. My rulings, these instructions, or any other remarks that I have made do not indicate any opinion about the facts of the case or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements are made that you believe are not supported by the evidence, you shall disregard them. The court will now explain the law applicable to the charge in count 1 of the indictment, first-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state of Tennessee must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed Lorenzen Wright, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed in the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits the offense of second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed Lorenzen Wright. And 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been defined in these instructions. The distinction between second-degree murder and voluntary manslaughter is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits the offense of voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed Lorenzen Wright. And 2, that the defendant acted intentionally or knowingly. And 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally and knowingly have been defined in these instructions. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible killed Lorenzen Wright, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The definitions for intentionally and knowingly have been provided in these instructions. Criminally negligent homicide. Any person who commits the offense of criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of Lorenzen Wright, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when a person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. The definitions for intentionally, knowingly, and recklessly have been provided in these instructions. The court will now explain the law applicable to the charge in count 2 of the indictment. Criminal conspiracy. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of criminal conspiracy, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained. And 2, that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder. And 3, that each party, acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder, agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder. And 4, that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of the conspiracy. The term intent has been defined in the definition of intentionally and the first-degree murder instructions. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. The essential elements necessary to constitute first-degree murder have been already set out and explained in count 1 of these instructions. The court will now explain the law applicable to the charge in count 3 of the indictment. Criminal attempt first-degree murder. Any person who attempts to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible intended to commit first-degree murder of Lorenzen Wright, and 2, that the defendant or one for whom the defendant is criminally responsible did some act intending to complete a course of action or cause a result that would constitute first-degree murder under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of first-degree murder. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit first-degree murder. The definitions for intending, and intent have been provided in the definition of intentionally in the first-degree murder instructions. The essential elements necessary to constitute first-degree murder have already been set out and explained in count 1 of these instructions. Criminal attempt second-degree murder. Any person who attempts to commit second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible intended to commit the specific offense of second-degree murder of Lorenzen Wright, and 2, that the defendant or one for whom the defendant is criminally responsible did some act intending to complete a course of action or cause a result that would constitute second-degree murder under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of second-degree murder. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit second-degree murder. Intending, and intent have been defined in these instructions. The essential elements necessary to constitute second-degree murder have already been set out and explained in count 1 of these instructions. Criminal attempt voluntary manslaughter. Any person who attempts to commit voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible intended to commit the specific offense of voluntary manslaughter of Lorenzen Wright, and 2, that the defendant or one for whom the defendant is criminally responsible did some act intending to complete a course of action or cause a result that would constitute voluntary manslaughter under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of voluntary manslaughter. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit voluntary manslaughter. The essential elements necessary to constitute voluntary manslaughter have already been set out and explained in count 1 of these instructions. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offenses of first-degree murder, second-degree murder, voluntary manslaughter, conspiracy to commit first-degree murder, criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. A defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. A defendant who is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another. If you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offense or offenses that accompanied the original offense have been proven beyond a reasonable doubt. To find the defendant criminally responsible for the acts of another, it is not necessary that you find the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find that all the essential elements of said offenses have been proven by the state beyond a reasonable doubt. Facilitation of a felony. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific felony of first-degree murder, second-degree murder, voluntary manslaughter, conspiracy to commit first-degree murder, criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and 2, that the defendant furnished substantial assistance to that person in the commission of the felony, and 3, that the defendant furnished such assistance knowingly. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The definitions for knowingly and intent have been provided in these instructions. Identity. One of the issues in this case is the identification of the defendant as the person who committed the crime. The state of Tennessee has the burden of proving identity beyond a reasonable doubt. Identification testimony is an expression of belief or impression by the witness, and its value may depend upon your consideration of several factors. Some of the factors that you may consider are: 1, the witness's capacity and opportunity to observe the offender. This includes, among other things, the length of time available for observation, the distance from which the witness observed, the lighting, and whether the person who committed the crime was a prior acquaintance of the witness. 2, the degree of certainty expressed by the witness regarding the identification and the circumstances under which it was made, including whether it is the product of the witness's own recollection. 3, the occasions, if any, on which the witness failed to make an identification of the defendant or made an identification that was inconsistent with the identification at trial, and 4, the occasions, if any, on which the witness made an identification that was consistent with the identification at trial and the circumstances surrounding such identifications. Again, the state has the burden of proving every element of the crime charge, and this burden specifically includes the identity of the defendant as the person who committed the crime for which he is on trial. If, after considering the identification testimony, in light of all the proof, you have a reasonable doubt that the defendant is the person who committed the crime, you must find the defendant not guilty. The court further charges you that if you are satisfied from the whole proof in the case, beyond a reasonable doubt, that the defendant, Billy Turner, committed the crimes charged against him, and you're satisfied beyond a reasonable doubt that he's been identified as the person who committed the crime charge, then it would be your duty to convict him. On the other hand, if you're not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, then you must return a verdict of not guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Presumption of innocence, the law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and this presumption stands as a witness for him, unless it is rebutted and overturned by competent and creditable proof. It is therefore incumbent upon the state of Tennessee, before you can convict the defendant, to establish to your satisfaction, beyond a reasonable doubt, that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and the state of Tennessee before the finding of this indictment, and that the defendant committed the crime in such manner that would make him guilty under the law here defined and explained to you. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Reasonable doubt is a real doubt of the defendant's guilt based upon reason and common sense, after a careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt, therefore, is proof of such a convincing character that you will be willing to rely and act upon it without hesitation in the most important of your own affairs. It is not necessary that the defendant's guilt be proved beyond all possible doubt, because absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. Direct and circumstantial evidence. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of a fact in issue without inference or presumption. Direct evidence might consist of testimony of witnesses who saw or heard what happened firsthand. If witnesses testified about what they saw or heard, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give to direct and circumstantial evidence. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. The law makes no distinction between the weight you may give to direct or circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Impeaching a witness. A witness may be impeached by proving that the witness has made some material statements at some point before the witness testified which are different with his or her testimony on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, you may consider proof of any prior inconsistent statements only for the purpose of determining whether the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Further, a witness may be impeached by a careful cross-examination involving a witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard the evidence and treat it as untrue except where it is corroborated by other creditable testimony or by the facts and circumstances proved on the trial. Prior consistent statements are admissible to rehabilitate a witness or to respond to impeachment by a prior inconsistent statement. The prior consistent statements cannot be considered by the jury as substantive evidence and is to be used only in assessing the credibility of the witness. Any prior consistent statement can be used only as corroboration of the in-court testimony of the witness after impeachment by opposing counsel. You may consider proof of any prior consistent statements only for the purpose of determining whether the witness is telling the truth at trial. The contents of the prior consistent statement are not to be considered as proof in the trial. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile those conflicts, if you can, without hastily or rashly concluding that any witness has sworn falsely. The law presumes that every witness has told the truth. It is your job to decide what the facts of this case are. When you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important you think that witness testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. 1, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? 2, did the witness seem to have a good memory? 3, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions? 4, has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? 5, does the witness have any bias, prejudice, or personal interest in how the case is decided? 6, did the witness have a motive to testify truthfully or to testify untruthfully? 7, have there been any promises, threats, suggestions, or other influences that has affected how the witness testified? 8, in general, does the witness have any special reason to tell the truth or any special reason to lie? 9, all in all, how reasonable does the witness testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. Accomplice. An accomplice is a person who knowingly, voluntarily, and with common intent with the principal offender unites with him or her in the commission of the crime. If a witness was an accomplice in the crime, then his or her testimony must be corroborated. Corroborated evidence is that evidence entirely independent of the accomplice's testimony, which, taken by itself, leads to the inference not only that a crime has been committed, but also that the defendant was implicated in it. This independent corroborative testimony must include some fact or circumstance that affects the defendant's identity. Corroborative evidence may be direct or entirely circumstantial, and it need not be adequate in and of itself to support a conviction. It is sufficient if the corroborative evidence fairly and legitimately tends to connect the defendant with the crime charged. It is a question for the jury to determine whether an accomplice's testimony has been sufficiently corroborated. Accomplice testimony cannot be corroborated by another accomplice's testimony. In this case, it is a question for the jury to determine whether the witness, Jimmy Martin, was an accomplice in the alleged offense of first-degree murder. If you find from the proof that the witness was an accomplice, then the defendant cannot be convicted upon the uncorroborated testimony of this witness. If you find that the witness was not an accomplice, then you would judge the weight to be given to his testimony just as you do that of the other witnesses in the case. In this case, the court charges you that the witness, Jimmy Martin, was an accomplice in the alleged offense of criminal attempt first-degree murder and conspiracy to commit first-degree murder. And before the defendant can be convicted, you must find this accomplice testimony has been sufficiently corroborated. Evidence of other acts. If from the evidence presented, you find that a witness has committed prior bad acts or been charged with other crimes, you can consider such prior acts only for the purpose of its effect, if any, on the credibility of the witness. Such evidence of other acts, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. Expert witness. During the trial, you heard the expert testimony of Tennessee Bureau of Investigation Special Agent Servinia Braswell, who was described as an expert in the field of firearms identification. You also heard the expert testimony of Dr. Marco Ross, who was described as an expert in the field of forensic pathology. You also heard the expert testimony of Sergeant Dennis Evans, Jr., who was described as an expert in the field of digital forensics and cell phone records examinations. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. In reaching their opinions, Special Agent Braswell, Dr. Ross, and Sergeant Evans testified that he took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied on as proof of the truth of the matters asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. As with any other witness, you must decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background, training, and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinion were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Defendant not testifying. The defendant has not taken the stand to testify as a witness, and you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state of Tennessee to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Admission against interest. Evidence has been introduced in this trial of a statement or statements made by the defendant outside the trial to show an admission against interest. A confession is a statement by the defendant that he committed the crime charged. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe is made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Prior statement of the defendant. The court charges the jury that if an oral or written statement given by the defendant has been proven in this case, you may consider it with all the other facts and circumstances proven in the case. In considering the statement, it is for the jury to determine what weight you will give the statement. You may believe any part of the statement or disbelieve any part of it, and you may believe the whole statement or disbelieve it in its entirety. Stipulations. A stipulation is an agreement. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. You are to regard the stipulated testimony as if it had been given in open court by any other witness. Jury notes. Members of the jury, the court charges you that if any of you have been taking notes in this case, your notes are for your individual use only. You shall not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. Your notes cannot be shown to others, compared, or referred to in any way as authority. Your notes can be used only as an aid to your individual memory. No outside communications during your deliberations. You must not communicate with or provide any information to anyone by any means about this case outside the jury room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, or computer, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including, but not limited to, Instagram, Snapchat, Facebook, TikTok, YouTube, Google, or Twitter, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. Unanimous verdict. Any verdict you reach in the jury room, whether guilty or not guilty, must be unanimous. Your deliberations will be secret. You will never have to explain your verdict to anyone. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to discuss the case with one another and to deliberate with a view to reaching an agreement. If you can do so without violence to individual judgment, each of you must decide the case for yourself, but only after a full consideration of the evidence with the other members of the jury. In the course of your deliberations, do not hesitate to re-examine your personal views and change your opinion if convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Selecting four persons. And ladies and gentlemen, I'm going to read the whole charge for you today. And we'll start with jury arguments on Monday morning at 10. So I'm going to read this whole charge. Normally I would have stopped reading the charge here, would allow the lawyers to present their closing arguments, but we will read the whole charge today. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have returned a verdict, you will return with your decision to this courtroom, and your foreperson will deliver the appropriate verdict form to the court. Multiple counts. The defendant has been charged with several crimes. The crime charged in each count of the indictment is a separate and distinct offense. The number of charges is no evidence of guilt, and this should not influence your decision in any way. It is your duty to consider the evidence that relates to each charge and to return a separate verdict for each count of the indictment. Your decision on one charge, whether it is guilty or not guilty, should not influence your decision on any of the other charges. The defendant may be found guilty or not guilty of all of or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. If you find the defendant guilty on all charge from the evidence beyond a reasonable doubt, you should convict on all. If you find from the evidence beyond a reasonable doubt one or more charges guilty and have a reasonable doubt as to the guilt of the other counts, you should convict on the counts you are satisfied by reasonable doubt as to the guilt of and acquit on the others. If you have a reasonable doubt as to the guilt on all, you should acquit on all. Deliberation order of consideration. In reaching your verdict, you shall first consider the offense of first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant guilty of first-degree murder or of being criminally responsible for first-degree murder beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of first-degree murder or of being criminally responsible for first-degree murder, or if you unanimously have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within the indictment. You shall not proceed to consider any lesser included offense unless you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in the indictment, you shall return a verdict of not guilty and proceed to the next count. The charge offense in count 1 of the indictment is first-degree murder. The lesser included offenses within the indictment are as follows: second-degree murder, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder or of being criminally responsible for first-degree murder as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant not guilty of first-degree murder or of being criminally responsible for first-degree murder as charged in the indictment, or if you unanimously have a reasonable doubt of the guilt of the defendant of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in count 1 of the indictment beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of blank as included in count 1 of the indictment. You will insert in said blank space the lesser included offense. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof, you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we the jury find the defendant not guilty of count 1. You write your verdict as count 1 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 1 of the indictment, you will next inquire as to your verdict in count 2. You will use the same rules in this count as you were instructed to use in the previous count. The charge offense in the indictment is conspiracy to commit first-degree murder. The lesser included offense within the indictment is facilitation of conspiracy to commit first-degree murder. When you consider your verdict in the indictment, you first inquire whether the defendant is guilty of conspiracy to commit first-degree murder or of being criminally responsible for conspiracy to commit first-degree murder, as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of conspiracy to commit first-degree murder or of being criminally responsible for conspiracy to commit first-degree murder as charged in the indictment, or if you unanimously have a reasonable doubt of the guilt of the defendant of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment, beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of facilitation of conspiracy to commit first-degree murder as included in count 2 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof, you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we the jury find the defendant not guilty of count 2. You write your verdict as count 2 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 2 of the indictment, you next inquire to your verdict in count 3. You use the same rules in this count as you were instructed to use in the previous count. The charge offense in the indictment is criminal attempt first-degree murder. The lesser included offenses within the indictment are as follows: facilitation of criminal attempt first-degree murder, criminal attempt second-degree murder, facilitation of criminal attempt second-degree murder, criminal attempt voluntary manslaughter, facilitation of criminal attempt voluntary manslaughter. When you consider your verdict in count 3 of the indictment, you will first inquire whether the defendant is guilty of criminal attempt first-degree murder or of being criminally responsible for criminal attempt first-degree murder as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of criminal attempt first-degree murder as charged in count 3 of the indictment. If you unanimously find the defendant not guilty of criminal attempt first-degree murder or of being criminally responsible for criminal attempt first-degree murder as charged in the indictment, or if you unanimously have a reasonable doubt of the guilt of the defendant of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment, beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 3 of the indictment. You'll insert in said blank space the lesser included offense. If you find the defendant guilty, you can convict him of only one of the above-named offenses charged and included in the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we the jury find the defendant not guilty of count 3. You write your verdict as to count 3 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. Ladies and gentlemen, I've talked to you about the jacket and how you go about recording that verdict on Monday. It is 2:42, and as I told you before the break, you will probably hear 3 arguments. And I can't put time limits on lawyers' arguments. One day this course will define what they mean by what is adequate but not excessive. So those 3 arguments might take an hour and a half, they might take 3 hours, they might take 4 hours, and then you have to deliberate on this case. And one of your members, at least one, I'm told there may be more than one, indicated to the judge, we really don't want to work tomorrow, can we come back first thing on Monday morning? There are, if my math is correct, don't hold me to that, I think there are 19 possible verdicts you can reach on this case. 19 possible verdicts, including 3 verdicts of guilty as charged, 3 verdicts of not guilty of anything, and some 13 verdicts that could be reached on included offenses. Now, I'll talk to you about that on Monday also. It's not a menu. It's not a multiple choice test. Once you start deliberating on the case, you don't go back to the jury room and say, which one of these sounds better? Or I have multiple choices and which one of these do I think fits? You cannot consider any lesser offenses on this case unless you unanimously made a decision that Mr. Turner is not guilty. For instance, in count 1, you deliberate on whether or not he's guilty of first-degree murder or criminally being responsible for that offense. If you find unanimously beyond a reasonable doubt that he's guilty, you record that verdict. If you unanimously find he's not guilty of first-degree murder or unanimously have a reasonable doubt, then and only then can you consider the lesser included offenses, and you start with second-degree murder. But you cannot consider any lesser charges in any counts of this indictment unless you found him not guilty of the charged offense or unanimously have a reasonable doubt as to whether or not the state is in fact proven that he's guilty. Does everyone understand that?
Yes.
Thank you for your patience. We'll find something for you to do tomorrow, movies or maybe the zoo or I don't know, maybe bowling or some other activity. If there's somebody, I know some folks says, Judge, I don't want to work on Sunday, it's a religious day. If we can find somewhere in a hotel in your hospitality suite, some services, church services that you may be interested in watching, they will put those services on at a live streaming because a lot of churches still are not holding services necessarily in person. A lot is still holding live streaming services. So we find something for you to do. Enjoy your day off. It's supposed to be a little bit warmer tomorrow, a little bit more sunshine. And we'll see you back in court on Monday morning at 10 o'clock. I will qualify the next grand juries for the March term, 24 folks just like you that will be setting and meeting on every Tuesday and every Thursday for the next 2 months. And we'll start hearing arguments on the case at 10. You cannot discuss the case with anyone else. You cannot discuss the case amongst yourselves. You've heard all the law. You've heard all of the evidence that you will receive in this case, but you cannot start discussing the case until the lawyers have completed their arguments and have discharged 2 alternates, and then and only then can you start discussing the case. So when you're out and about over the weekend, over the next, 36 hours or so, don't be in little circles or little bitty private meetings and say, hey, what do you think? What do you think? And when we go back to court on Monday, we're going to already have this case decided. You cannot discuss this case at all until the alternates have been excused and you've been discharged with this jacket and all the trial exhibits to start properly considering the case. Let me know how the deputies are treating you. Let me know how the food is, how the accommodations are. And if you have any special requests, let the deputies know because we're going to hold you as guests of Shelby County over a period of time where you would not be in court for about 36 hours or so. And that's asking a lot. But as I told you on Monday, if any one person says, Judge Coffey, Sunday is not a good idea to hold court, we stop and we would not hold court on Sunday. And I give deference to folks in their religions because I do not trample on a person's religious beliefs. That would be unconstitutional for me to do that. Thank you for your patience. Thank you for your patience this whole week. We'll see you on Monday, and it's probably sometime early Monday afternoon you will be deliberating on this case. You can follow Deputy Smith. Have a great weekend. for the record, that conversation with those last 3 jurors, they wanted to know how my finger was doing. So I gave them a short answer that I need a housekeeper. Long answer is it'll take 3 or 4 months for it to fix itself. Anything else we need to address before we adjourn for the weekend?
Nothing important, Judge.
Yes, sir.
One of the exhibits introduced in the trial was a photo identification by Jimmy Martin of Billy Turner. Don't know what number it was.
Yes,
By
sir.
the time it was introduced, it was 2 pieces of paper, the actual photo spread that's circled and this advice of rights. The witness looked at both of those things, and I think it should have been a 2-page exhibit, but this advice of rights keeps on appearing on the table without the exhibits.
Yes, sir. That came in through Mr. Martin.
Yes, sir.
Madam Clerk, that should be exhibit number 76. Should be 76, and I'm sorry, Jimmy Martin. Okay, that was the advice rights to the witness viewing a photographic lineup. Okay, exhibit number 76, that photographic lineup. And I think when it was handed to me, I think it may have been handed just the photographic spread itself and not the advice, and that's how I got separated. But I will append to exhibit 76 the advice of right as well as the photographic display. Will staple it together so it doesn't get separated again, and it will be appended as a collected exhibit rather than just the photo lineup, because what was handed to me was just that one piece of paper that got separated. That part was not marked. In fact, it would have probably, not probably, it would have marked them separately, because I hate marking different items with one number, because sometimes they get separated and it may get confusing with the appellate courts if they come up as a collected exhibit. But I'm appending the advice to witness viewing photographic display. Mr. Martin identified that he looked at before he identified allegedly Mr. Turner, and that has the sticker 76 on it. And I'm putting the advice in front of that so that it would in fact show it is exhibit 76. Anything else?
One more thing, Mr. Approach, real quick.
Yes, sir. Does it need to be on the record?
No,
No? Okay. Let me call the court into I'm sorry, you may adjourn court was not adjourned to 9 o'clock Monday morning, March 21st, 2022. Will impanel the grand jury for the March term 2022 for Shelby County, Tennessee at 9, and we'll start jury arguments at 10 o'clock. Court stand adjourned Monday morning.
All right.